Mr. President and Mr. Arbitrator, good afternoon. My name is Brandon Zhang, and I appear on behalf of FIFA. This case concerns the integrity of football and whether the evidential record, when viewed holistically, reaches the standard of comfortable satisfaction. Our submission is that it plainly does. The respondent applied established procedural safeguards and carefully balanced fairness considerations, and relied not on speculation, but on a convergence of mutually reinforcing evidence. I'll make first two submissions: that the anonymous evidence is admissible because sufficient counterbalancing factors, safeguards, preserve the fairness of the proceedings, and second, the evidence comfortably satisfies the standard for match fixing under Article 12 of the FDC.
Just a preliminary questions before you move on to your submissions. Why did FIFA choose to bring these proceedings? In the sense that, isn't there a risk of parallel proceedings or maybe conflicting decisions? Because ultimately, the public prosecutors are also considering the issue of whether there has been match manipulation, right? So maybe it would have been more prudent for FIFA to just wait until the prosecutors have concluded their case and then maybe rely on the evidence instead.
Mr. Arbitrator, the prosecution's office has been investigating for 7 months. That is a criminal state proceeding. This is a sporting tribunal, and the FIFA organization does not have to wait for those proceedings in respect of bringing the case forward. Turning to the issue of anonymous evidence, under Kareem Karamuddin versus FIFA, the key inquiry is whether sufficient counterbalancing safeguards exist such that proceedings remain fair overall, despite the limitation on cross-examination. The panel considers 3 limbs to admit the anonymous evidence: whether there's a concrete risk, whether the evidence is sole or decisive, and whether sufficient safeguards preserve fairness. I'll address 3 each briefly in turn, and we submit we satisfy all 3 limbs. Now, the appellant had argued on 2 factors. First, that there was no risk, and second, there was no cross-examination. We submit that there is a risk of physical retaliation and reputational harm if the anonymous witnesses were subject to cross-examination, or if the evidence was admitted. Here on page 14 of the record, if I may direct the panel, at the very bottom line, the 11 players have already been identified by name in the Genius report, and any further exposure through either cross or through the evidence will subject the witnesses to more exposure and create a risk of identifying them to the potential criminal organizations that are being allegedly involved.
So are you arguing some sort of whistleblower protection, and if so, is there a set of rules for that?
The rule against anonymity is not absolute. Under Karamuddin, the court assesses the overall fairness and whether there are counterbalancing factors to safeguard against this. The audiovisual protection is only a guideline found under the CAS guideline rules on evidence, which is in the legal authorities of the appellants. It is not absolute, and distinguishably from Karamuddin, in that case, that was not a case about match fixing. In that case, the 5 anonymous witnesses were granted asylum, and only then the panel required audiovisual protection, because after they would give their testimonies, they would be moved away safely into Europe because they had been granted asylum in Europe. At the time, they were 5 women playing for the Afghan national football team who were alleging rape allegations and death threats. Here presently, this is a match-fixing case, and the players are still actively on the national Iridonian team. And therefore, we submit that there is a risk, and we submit that the that the audiovisual protection is not
But
necessary.
risk from who? So when you say potential criminal organizations, like what do we?
On the facts of the record, there is allegations of a criminal organization who is involved and connected with the father of the appellant in the overall broad scheme of the match manipulation which had occurred.
Right, but I mean, besides that, what other evidence do we have available that suggests that there are links between the appellant and the father being part of a criminal organization? Is it just this guy saying, oh, I heard his dad is a mafia boss or whatever?
Precisely, Mr. Arbitrator. There is other evidence. The Iridonian public prosecutors have also launched an investigation on the anonymous evidence. On the email itself triggered the investigation. And
what is the email?
the email is on page 30, 35 and 34 of the record here.
Is it true? Okay, yeah, sorry, please proceed. Yeah.
The relevance is not that the prosecutors concluded guilt, because it's still ongoing, but that an independent state authority considered the actual factual matrix sufficiently serious enough and credible enough to justify its own criminal investigation. We submit that this evidence crosses the threshold required of a concrete risk to be found by the panel today. Now, turning to the second issue of liability, we submit that the appellant is liable of breaching Article 20 of the FDC. First, the applicable standard is comfortable satisfaction, and the panel has held consistently that match fixing is rarely established through direct evidence, but on a convergent set of strands of evidence. And here we submit the evidential strands converge in two ways. First, the nexus between the conspiracy and the appellant's conduct, and second, through the nexus linking appellant to the broader betting scheme. Here, the betting patterns in the Genius report were highly irregular. There was a red rating. Prima facie, this would be match fixing already. Outsider heavily backed, and also within the final hour, the betting surged. As Mr. President had early queried, the evidence is not sole or decisive either, because this is concrete, objective evidence in the Genius reports. And the significance is not merely the betting volume, but the timing and the direction of the market movement itself. The markets were suspended shortly before the goal was conceded, and immediately thereafter, the appellant engaged in highly irregular conduct, resulting in an empty net goal. This temporal alignment is highly probative.
What do you make of the opposing counsel's argument that said that apparently he had saved a very difficult to save goal in the final minutes of the game? And that seems to show that actually, if he had really been part of the scheme, he could have just let that goal pass, but he didn't.
Yes, Mr. Arbitrator. The significance is not merely that Cometland not only was it heavily backed in the betting markets, but that there was a concentrated betting on the highly specific outcome. Now, this ties to your question, Mr. Arbitrator, because the bets was a 0-2 scoreline, which ultimately then materialized in the game. The very fact that at the 82nd minute, right before the game ends, whether or not he saved the goal or did not save the goal had no relevance, because at this point, at 0-2 score, the match manipulation had already been perfected, and the money was already made on the bet. Here, the probative value increases with the specificity of the bet. The correct score betting on the outsider victory, because here they had an 83% chance to lose as the bottom ranking team, is materially more difficult to explain as ordinary market behavior once predicted the outcome later, which occurs. I know my time is up, unless if there are any other further questions I can address. This concludes my submissions.
Thank you. Oh, if you